respectfully ask the court that we deal with her application, the first application. She had the advantage, or the prosecution had the advantage of appearing before this court on 13th of July and persuaded the court to hold the respondents for 15 days. In fact, they were held longer than the prosecution asked for. And for a period of more than 14 days. So, Your Honor, let's deal with the application, first application. And if you find merit in that application, then we can proceed on the basis of the ruling on that first application. You know, I can give the citation later if you can remember the case against the Deputy Chief Justice of the Republic of Kenya, Honorable Mwilu. She was brought to court on a variety of charges. And when the court determined that there was a violation of the Bill of Rights, those charges were terminated. You know, we want to demonstrate to this court that the proceedings and the issues that arose during the proceedings of this current application were in violation of the Constitution and the Bill of Rights. So the foundation of the case that they propose to bring against the respondents violated the respondents' constitutional rights, Bill of Rights, and the Honor should not make any further orders other than their release, and direct the police not to touch them until there's a proper charge before the court. You can already hear of the mischief that please hold them for another day on a charge that we don't even have the copy of the charge. You're being told, hold them for another day. And forget about what has happened in the proceedings subject matter of the miscellaneous application. So we want to address you at some length on why the prosecution should not trample on the constitutional rights of whoever appears before the courts or outside the courts. The Bill of Rights extends to those in custody, lawfully in custody. It extends to arrested persons, and is the foundation of our constitutional order. You know, I didn't know this was going to happen, but just 3 weeks ago, Honorable Babu, Owino, and I appeared in a court where a person was charged with treason. There can never be a more serious charge than treason or murder. And held in custody for nearly 3 weeks. The court declined to give them any further opportunity to abuse the rights of the accused persons. We have been waiting for those treason charges. Honorable Babu Owino is here. We have been waiting for those treason charges. They have never come. And to impress the court, they were talking about a murder case. The principal application was made on the basis of a murder charge, which was in the affidavit, and the application was the first charge referred to. There is not going to be a murder charge. In fact, from what I've heard of her, there is not going to be a murder charge. So that charge was put in the application to persuade the court that there was a serious charge that the court needed to consider in determining whether to release them or not. The prosecutor is nodding her head actually as I speak and saying there's not going to be a murder charge. So I'd ask you, Your Honor, that you allow us to address you on this application. Principally, Honorable Babu Owino and Faith Odhiambo are going to address you, and then I'll conclude.
Oh, Your Honor, I've had the sentiments of my colleague Tina. Perhaps I can withdraw the second application, save the court's time, so that will be the first application. But I know for a fact that charge sheet is currently being approved, but I don't think there will be any trouble in arresting the accused persons. However, the arrest can be issued later if they are not within the court's premises. So we can just deal with the first application.
Your Honor, then in light of her concession, then proceed with the first one, and they can, if they want to arrest, if they have any charges as alleged, then we can.
No, we say they should not close. The thing, there should be no orders at all. And there should be a direction to the police not to arrest them until a proper charge is filed.
She's saying a charge has been filed.
No.
No, she's saying if they can be rearrested if they're not within the court premises.
And the charges have not been approved.
Yeah, they're not. So we wait when the charges will come back.
Your Honor, the state has decided to sit down and to clearly tell you that the application that they brought before you was an infertile imagination. Your Honor, when you look at some of the reasons that were given to you to detain the 8 innocent accused persons, then you will realize the unseriousness of the DPP
in this matter. Were to be detained for a further 10-day period because an ID parade was to be conducted. And Your Honor, up to now, up to today, an ID parade has not been conducted. Your Honor, why would the prosecution come before this honorable court to lie to this court? You even know the circumstances under which an ID parade should not be conducted. And in the same affidavit, they clearly stated that the accused persons, the arrested persons, were allegedly searched and found with pangas and rungus. Found with pangas and rungus, allegedly, which means that they were caught in the act in flagrante delicto. Court redundant, according to them. That alone, Your Honor, ought to have disqualified the idea of the ID parade. And that, Your Honor, you are told that the arrested persons had no fixed abode. Your Honor, machinery to identify, including but not limited to even tracking. During the Genz protest, these officers were illegally even tracking phone numbers and abducting these same people. And so the idea of a fixed abode, Your Honor, should have not been a sufficient reason. Because these were churchgoers, God-fearing men of God. They were arrested in church, Your Honor. And the police officers are just here looking at us. What a shame. Your Honor, the prosecution asked for 10 days. 10 days. 10 days to conclude the investigation. 10 days. Number one, 15 days were granted. And that leads me to speak to the spirit of Article 159, Article 159 on the administration of justice, Your Honor. Prosecution comes before you, Your Honor, to ask for 10 days. Then the court, in its own wisdom, found it fit to grant 15 days. Your Honor, justice administered under pressure ceases to be justice. Justice administered in fear ceases to be justice. Justice administered to satisfy the executive ceases to be justice. And there is only one standard measure for justice, and that is the constitutional justice. Your Honor, justice denied, justice delayed is justice denied. And today, we are experiencing miscarriage of justice. These gentlemen are innocent before this competent court of law under Article 50, Subarticle 2A, the doctrine of innocence until the contrary is proved. Your Honor, Article 157.11 speaks to the heart of the DPP. That the DPP should act in a manner that promotes public confidence. What is before you today here, Your Honor, is DPP acting in a manner to promote self-interest. Why self-interest? Because up to now, Your Honor, 10 a.m., there is no charge. We are being told that it is yet
To be approved.
to be approved, Your Honor. Yet to be. 1 second of detaining these innocent Kenyans denies them their constitutional right to liberty under Article 29 of the Constitution of Kenya. Right to liberty. And liberty is the grammar of life. Your Honor, jail term starts with 1 day, 1 second. Jail term starts with 1 second. 1 minute is so much time if a person spends in jail. To detention without trial. Your Honor, a right to fair hearing is being tested before you, and history will remember you, Your Honor. And we shall give examples that at some point we were before you, Your Honor. Article 52 talks about right to fair hearing. Your Honor, do not allow your court to suspend that right, just to satisfy the state. Your Honor, today we are not here this court is not trying the charges that you're being told, allegedly, that are yet to be brought before you. These allegations, if they are there, will await trial, Your Honor. Today this court is testing something else, Your Honor, something else and very important. And that is the Constitution itself. The Constitution itself, Your Honor. So will Article 49, Your Honor, survive this political heat before you? Or will it become a fair weather promise? Your Honor, these accused persons cannot surrender their constitutional right. Not even at the police station, cannot suspend and cannot surrender their constitutional right. Not even at the door. The Constitution is meant to protect them where they are as we speak. Your Honor, history will remember judicial officers who defend the Constitution, who defend the constitutional principles when doing so was unpopular. Already, Your Honor, 10 days were asked. The court, in its generosity, grants 15 days. Days that were never asked by the prosecution. And the Constitution of Kenya deliberately places liberty before conviction. Liberty before conviction. Because it presumes innocence before punishment. Today we are punishing 8 innocent Kenyans. Honor, by asking for 10 days. Because the norm should be investigate, arrest, charge. Today, arrest, come to court, ask for 10 days, court gives you 15 days, then come back to court and say that our charge sheet is not ready. Your Honor, what type of a country are we living in? History will judge all this, Your Honor. And we shall live never to forget what is happening today. Your Honor, therefore, it is my prayer that you close this file. You close this file. We had a matter, as the senior counsel has mentioned, of treason, an alleged treason. The magistrate, in his own wisdom, closed that file and closed the file, ashamed the rebels, and told the DCI never to joke with justice, Your Honor. We are all equal before you, Your Honor. Therefore, kindly release these innocent Kenyans. Thank you.
Without conditions.
Without any condition, Your Honor. If they are ready with their charge sheet, we will come back for you. We are available. Because you are our meal. We want to dine. We want to feast on you. Thank you, Your Honor.
You want to say something? Yeah.
My lady, I think my colleagues have said enough on the matter. But just to add, we should not allow the judiciary to be used as a tool of oppression and frustration for normal Kenyans into the criminal justice system. Because this is a trait we have seen from 2024, where a lot of our young innocent Kenyans were bounced between courts to courts to ensure that they are frustrated, they do not exercise their constitutional rights. Just looking at this back and forth that we've continued to play, and the rules that they have used to beguile our honorable courts to hold these young men longer should not be allowed. And in fact, I urge that the honor should even be stern against the prosecutors, because they should not come before you if they are not sure of what charges they want to levy against these given individuals. It was indicated they were supposed to go through a parade, they were supposed to go through DNA analysis, but now all of that has been cancelled and saying they want to now issue different charges. Because they have seen they have already wasted the court's time and held them for over 15 days. Now they want a new date that they want to give. My lady, we should never allow the criminal justice system to be used as a knife against the very Kenyans that this constitution was aimed to protect. The justice system and the courts have always been known to be the halls that defend the weak, defend the innocent, defend the poor. My colleague has said that we truly are equal before the law, but the law can also be used as a tool of oppression and great injustice. And therefore we urge that these innocent individuals should be released immediately, and they should be allowed to enjoy their right to liberty. Our courts should always uphold the very basis of our constitution under Article 50, that you're innocent until proven guilty. Let them prove their case. Let them not use these halls that are supposed to be sacred as a tool to ensure repression, as a tool to ensure frustration. Kenyans have been crying about whether they can get justice in our courts, whether they can trust in the dignity and integrity and independence of our courts. And so we ask you to ensure that independence should be spoken loud and clear, that our courts shall never be used as a tool to ensure frustration, but rather as a hallmark of justice, and will defend always the poor and the vulnerable. And therefore we urge that, and it's our humble prayer, that they will be released effective immediately with no further conditions. Thank you, my lady.
Your Honor, sorry once again. We pray that the ruling be delivered extempore because of any justice they still amounts to justice denied. Thank you.
Your Honor, in conclusion, I just want to talk about two things. You should ensure there is no abuse of the court process. And Your Honor, I'm saying this because before you, there was a submission that the respondents are likely to interfere with witnesses. It is trite law that on that issue, the prosecution should not make any submissions which is not supported by evidence. Material evidence to demonstrate that they are able or likely to interfere with witnesses. They were allowed to make the submission that the respondents are likely to interfere, there are flight risks. Normally, a judicial court cannot make a judgment on that question without material evidence. So what is the court to do in these circumstances that we find ourselves in? I think one, as has been prayed by the prosecution, is to close the file. And secondly, because there's been an abuse of the court process, in effect that there was going to be a charge and there's no charge, and the prosecutor has clearly indicated that the respondents should be held until a charge is filed before the court, a charge which has not been approved. We pray that you make an order that when such a charge is filed before the court, because the charge has not been approved, but if such a charge has been approved and ready for registration or trial in court, the respondent should be served with summons to appear. Either through counsel or through the respondents themselves, or both. So that the respondents should not again suffer pre-trial detention. Which they have already suffered 15 days of pre-trial detention without an indictment or without any charge before the court. Just to defend and protect the principle ingrained in our Constitution of presumption of innocence, it should find favor with the court that they should be summoned when the prosecution is ready and the matter is properly before the court. So that we don't have some fictional release, is playing around with justice, that they walk out of this courtroom and on the steps of the court or within the court precincts, they are again arrested. I think that will be playing around with the justice system. We pray. And then you say, even a second. Even a minute. Actually, on the second, you can say that I've already served. When do you want to go back? You want to go back today? William. Okay. Okay, go and have a cup of tea. she agreed with you to make an extempore. To make a ruling right away. Yeah. No, to walk outside the court. See the yellow. Yeah. But if she's courageous, she should just tell them they're free to go, and they'll be summoned, because there may be no charge sheet. I don't know what she's talking about one day. But she didn't tell that court that it's ready.